Hello, welcome once again to Leto's Law. I'm Steve Leto. Today we're going to do an update on the parking situation with the chalking of the tires. Here in Michigan, the Sixth Circuit Court of Appeals recently ruled that it was unconstitutional for the police officers to chalk the tires of cars, calling that an illegal search. There's been a lot of talk about this on the news. News organizations across the land have spoken about this. I spoke about it when it first happened also. But there's been a lot of stuff that's come out since then, including some cities are now saying what they're going to do instead of chalking tires, how they can do a workaround with this. But first of all, let me tell you that the New York Times did a big piece on this. And the headline was Lose the Chalk Officer. Court finds marking tires of parked cars unconstitutional. And this all goes back to Allison Taylor, who sued the city of Saginaw, Michigan, over the practice of chalking car tires to enforce parking limits because she had gotten 14 parking tickets in 3 years. And, she says that there's a lot of people who actually work and have got to go out and take a look at their car to see if the car's tire's been chalked. If it's been chalked, they move it. If it hasn't been chalked, they don't move it. But of course, the point is that if your tire has been chalked, that means that they're counting how long you're there. And the law says that you can't be there for over a certain length of time, whether or not you're feeding the meter in most cases. But that's not the point. So Taylor sued the city of Saginaw, and on Monday, this is a little over a week ago, a panel of 3 federal judges hearing an appeal in the case ruled unanimously that the police practice of chalking tires to tell whether a car overstays the time limit is unconstitutional, saying it violates the Fourth Amendment's ban on unreasonable searches and seizures. They said, and that reversed the lower court's decision, which had dismissed the suit, and now it's being sent back to trial. So what happens, of course, is a parking enforcement officer marks the tires of cars parked in time-limited spots. When the officer returns later, the mark reveals that it has been there an illegally long time. And officers these days may also take time-stamped photographs to document the infraction. Chalking tires is the old-school way of doing it. This is according to Donald Shoup, a professor of urban planning at the University of California, LA. The first references I've seen to it were in the 1920s. They've probably been using chalk at that time. The practice is becoming less common, replaced by computerized meters, pay-by-phone apps, and digital vehicle recognition systems, including one that's called AutoChalk. The manual version has always been arbitrary and inefficient, the professor says. The enforcement is kind of random, so whenever you get a ticket, you say, why me? The legal campaign against chalking in Saginaw started on a weekday in the fall of 2016 when Matthew Granda, who's a local lawyer, was sitting in his car outside the county courthouse talking on the phone to another lawyer. And during their conversation, a parking enforcement officer came by and chalked his tire. Hey, this is a search, Mr. Granda recalled telling Mr. Ellison. They say it was out of curiosity at first that the two began to research the legal question of tire chalking, and they had an aha moment when they came across a 2012 Supreme Court decision called U.S. versus Jones. And that's the case of the GPS device that had been placed on the guy's car without a warrant. The police had just stuck a GPS device in his car and were tracking where he went. The Supreme Court had ruled unanimously that Mr. Jones's Fourth Amendment rights had been violated, but they were divided on exactly why that was so. In a concurring opinion joined by 4 justices, it was the long-term surveillance of Mr. Jones made possible and even easy by technological advancements that was a real issue. But Justice Antonin Scalia, writing for the 5-justice majority, held that the heart of the matter was the physical placement of a device on Mr. Jones's private property for the purpose of obtaining information, and that was government trespass. And the point is, I remember reading about that case where the police just decided to track a guy and they stuck a GPS thing in his car and started tracking where he went. If that's not an invasion of your privacy, ain't nothing. I mean, that's bad, But the point that Scalia is pointing out is that, and it doesn't have to be a major, how do you measure how much the intrusion is? It's not necessarily how the size of the chalk mark or the size of the GPS unit or any of those things. It's more a matter of, how are they interacting with you? Do they have the permission to do what they're doing with your stuff? And so the trespass theory went too far and not far enough, said Peter Swire, a privacy law expert who teaches at Georgia Institute of Technology. On the one hand, he said it didn't go far enough in Jones because it seemed to allow for tracking locations as long as no one touched the car. But on the other hand, he continued, it went too far because even tiny touches become illegal. And of course, a tiny touch with a chalk mark is what we're talking about in Saginaw. So, Mr. Granda said this case was filed basically because of the Jones case, which they thought was a great parallel. While the two lawyers were researching the issue, Ms. Taylor came across a Facebook post by Mr. Ellison, and she said he was kind of venting about the ticketing process, and so she joined the comments, and next thing you know, it's a match made in heaven. So the lawyers had their plaintiff. Ms. Taylor had gotten 14 tickets in 3 years, and so, of course, now she becomes not just the poster child, but the plaintiff in a case. So, the trial court that heard her suit sided with the city in a 2017 decision, agreeing that chalking constituted a search, but finding that it was a reasonable search. Among other legal rationales, the judge found that the police have the authority to enforce parking regulations. That's true. Even to tow cars as an exercise of community caretaking. But they're usually towing a car because a law has been broken. Because I've had several people have asked me about that. They said, well, Steve, if they can't chalk your tire, why can they boot your tire? Well, they're booting the tire because presumably there's unpaid tickets, which means there's already violations in place. They couldn't boot your car preemptively in case you're going to break the law. Okay? So, it is unclear what will happen now in the wake of this decision, which is binding in the 4 states that are the Sixth Circuit. I mentioned that before: Michigan, Ohio, Kentucky, and Tennessee. But the Downtown Development Authority in nearby Bay City announced this week that in light of the ruling, it will no longer chalk cars. They're working on alternatives, and this is where we get to now. So that's Bay City. And there's another city nearby named Owasso. Owasso. I like saying that name. I don't know why. Owosso. Owasso. And they announced this past week, and this is according to ABC 12. Amy Hybels is the journalist. City of Owasso to implement live tire system parking enforcement soon. The city of Owasso plans to implement a new parking enforcement system in the wake of Monday's appeals court ruling about chalking of tires. Local reaction to the planned change depends on who you ask. Dan Gallagher said, it's important people respect the parking that's available. There's limited parking available downtown, and some people would take advantage without some type of enforcement in place. The owner of the downtown frozen yogurt shop is pleased with the planned changes. You put the plate of the car and the make of the car into the system with this is how the new system works. There's a system called the Live Tire System. It's an electronic handheld device, and you put the plate of the car, the make of the car, where the valve is of that particular tire to see if it was moved. And this is according to Public Safety Chief Kevin Lenkert. After 2 hours, the vehicle will be cited if it's parking in a spot with a 2-hour limit. It'll be more accurate, it'll be more exact, and unlike the chalk marks, it's more discreet, but the key is they don't touch your car. They walk by your car, they look at your car. No one's got a problem with someone walking by and looking at your car. Okay? It's the chalking that's the problem. So, Hannah Harwood said, I like that they're getting away from the chalking. It's going to be a lot easier to tell how long somebody's been there. Harwood feels the new method will be more accurate, but as the mother of a toddler, she wishes they would up the parking limit outside of downtown shops and restaurants to 3 hours instead of 2. A nearby beauty salon owner says, we get really nervous over a 2-hour limit. As a large portion of her clientele are seniors, being in the beauty shop business, we'd rather see a 3-hour limit. Apparently, some people take 3 hours to get their beauty. While all downtown parking in Owasso is free, if you go over the 2-hour limit, you do face a $15 fine. In addition to the 2-hour parking spots, there is a 4-hour parking behind the shops and a 72-hour parking lot located next to the Armory, just in case you're in downtown Owasso and you need to park for a couple days. One of the shoppers that they spoke to outside of the Friday's farmers market thinks that the fines penalize people who come downtown to shop. You know, it's funny, I've mentioned before I used to live in Bad Axe, Michigan, and I worked at a radio station called WLEW. And I used to, of course, produce commercials that be aired on the radio. And I also played commercials during my radio broadcast. And I used to listen to the commercials, and I knew a lot about the local businesses as a result. And I learned that the nearby town of Pigeon had no parking meters. And the reason I know that at the time is that they used to run in the ads for the downtown shops of Pigeon. They'd say, please come shop in the free parking town of Pigeon. So Pigeon, and that's a town just kind of northwest of Bad Axe, up on the thumb of Michigan in Huron County. One of the three towns that makes it the school district at the time of Elkton, Pigeon, Bayport. And I think it's still a school district, but I could be wrong. Been a while since I looked into that. But the point is that, if you're trying to market something, you got to go with everything goes your way. And you point out that the shoppers in Pigeon can park for free. Whereas if you go into the big town of Bad Axe, you may have to feed a meter. Just letting you know that. So the free parking town of Pigeon, my friends, is where it's at. Now, this woman they interviewed says she thinks parking should be completely free, meaning no limits on how long you're allowed to park. Then people don't have to worry about whether I'm going to 1 or 3 shops or have dinner. And there is a reason, of course, for the limits. According to Lenkert, each downtown parking spot generates more than $11,000 in revenue for the city each year. By keeping the spots open, that allows other vehicles to come in for those 2 hours, do their quick shopping, stop at a restaurant, and move on. And, that's the whole thing about parking, and there's a debate about this, and I understand this, that, a lot of people think that if you have a parking meter and it's got a 2-hour limit and you park there, if you come back in 1 hour and 59 minutes, you can put 2 more hours in the meter. And in some cities, that's illegal. In some cities, the 2 hours is for you to park and then you to leave at the end of the 2 hours. And in some cities, you can be ticketed even if you stay over, even if you put money in the meter. It's not an expired meter, it's overtime in the spot. And I've had people say, well, that's stupid. No, but the meters aren't there to generate revenue only. They're there to do a turnover on the parking spots. Because if you have all the best spots taken by cars that don't go anywhere, then the shoppers or other people who want to come in and conduct a little bit of business can't find a place to park. And we've all seen this, where there are poorly run businesses where the employees park their cars in the best spots and the customers have got to park farther away. And I've spoken to people who worked places where they said, by the way, if you work here, you got to park at the back of the lot. Okay? You park back there so our customers can park up here. Okay? So, same concept applies. And there have been some controversies. I remember in Detroit, for instance, there was a building downtown that was filled with government workers. And all of the metered spots around the building, around the closest curb to the building, were all handicap meters. Meaning that you could park there and put money in the meter so long as you had a handicap placard on your car. And so what happened was many of the workers in the building simply went to their doctors and go, I need a handicap placard so I can get one of those good spots. And so the next thing you know, all the spots are taken all day long by cars that don't move. And even though parking enforcement is supposed to ticket those cars, they feel bad because these people are handicapped. Until somebody narked them out and a news organization came down and actually did some surveillance and noticed that all of these cars belonged to employees, many of whom didn't appear to be handicapped. But that's another story altogether. So, here's the deal. As of right now, Sixth Circuit case still on the books. Tire chalking in these 4 states is unconstitutional, not enforceable as a means for enforcing parking tickets and overtime at meters. There are methods around this, which they're going to do, and we will follow the situation as it progresses. Questions or comments, put them below. Let's talk to you later. Bye-bye.